Judgment in the appeal, Crawford Adjusters and others against Sagicor General Insurance Cayman Limited and another.
Lord Wilson will give the judgment.
This appeal requires the Board of the Privy Council to consider a little-known area of the common law known as the tort of malicious prosecution. It is clear that if I bring a criminal prosecution against you maliciously and without any reasonable basis, then, after you have been acquitted, you can sue me for damages to compensate you for any losses which you have suffered as a result. But can you sue me after you have successfully defended a civil action which I brought against you maliciously and without any reasonable basis? Mr. Patterson, who is in reality the claimant, is a loss adjuster on the island of Grand Cayman. In 2004, he contracted to do a piece of work there for Sagicor General Insurance. Mr. D'Alessio became a vice president of Sagicor. There was ill feeling between the two men, and Mr. D'Alessio was obsessed by a desire to ruin Mr. Patterson. Mr. D'Alessio caused Sagicor to sue Mr. Patterson in relation to his work under the contract. Sagicor claimed that Mr. Patterson had made fraudulent representations to it and had conspired with a construction company to deceive it about the value of works for which, as the insurer, Sagicor was liable to pay. Mr. D'Alessio then planted an article in the island newspaper to the effect that Mr. Patterson was being sued for fraud. The publicity caused substantial damage to Mr. Patterson's practice. On counsel's advice, and almost 3 years after it had been issued, Sagicor abandoned the claim. It was ordered to pay Mr. Patterson's costs. He thereupon counterclaimed in respect of his other losses. Shortly afterwards, Mr. D'Alessio committed suicide. The judge in the Grand Court of the Cayman Islands dismissed Mr. Patterson's counterclaim. He upheld his case all down the line, except in one crucial respect. Thus he found that, although Mr. D'Alessio had believed that Mr. Patterson had defrauded Sagicor, there was no reasonable basis for the belief. He also found that the allegations in the claim had been made maliciously, because the dominant motive for making them had been Mr. D'Alessio's obsessive determination to ruin Mr. Patterson. He also found that, as a result of the allegations, Mr. Patterson had suffered loss and damage amounting to $1,335,000 Cayman dollars, which is about £1 million. But he held that there was no such thing as a tort of malicious prosecution of civil proceedings. The Cayman Islands Court of Appeal dismissed Mr. Patterson's appeal. By a majority of 3 judges to 2, the board today advises Her Majesty to allow Mr. Patterson's further appeal. All 5 judges have written judgments, and 2 of them are laden with legal history. The minority considers that the tort has never applied to civil proceedings and that the law should be reluctant to encourage the extension of litigation by allowing successful defendants to complain about the first action in a second action. By contrast, the majority view is as follows. In earlier centuries, the common law did recognize that the tort extended to the malicious prosecution of civil proceedings. Then, however, in 1883, in a case called Courts Hill, the Court of Appeal in England and Wales suggested, for reasons which are no longer valid, that, except in a few miscellaneous situations, the tort no longer applied to civil proceedings. In this connection, there is no convincing distinction between civil and criminal proceedings. Mr. Patterson has suffered substantial loss deliberately caused by a man for whose actions Sagicor is responsible. The primary purpose of civil law is to remedy wrongs, and inherent in the common law are the flexibility and vitality which enable it today to recognise once more that legal liability does exist in these surely rare cases where baseless civil actions are brought maliciously and cause substantial loss. So the Board's advice is that Her Majesty should allow the appeal and order Sagicor to pay $1,335,000 to Mr. Patterson.